Mr. Forenza has been disrespectful to the court, to opposing counsel, and even to my clerks throughout the proceeding. He's filed spurious documents. He's made nonsensical arguments. He's been argumentative with the court. But I was willing to let all of that go so we could try the matter. On the day of trial, which I believe was November 24th, he told me I had no jurisdiction, left the courtroom, and then amazingly was able to leave the building as well. In any event, he has not returned since.
So here's what went down because a routine traffic stop on Riverside Parkway turned into a full-blown courtroom showdown, and Mr. Forenza, who calls himself a secured party creditor, is now looking at 25 days behind bars after walking out of his own trial mid-hearing and leaving 30 jurors sitting there with nothing to do.
Are we having a contempt hearing, Your Honor?
Well, I'm going to give you that opportunity. I'm going to advise you if you'd like it. Let me start by reading the relevant portions of the contempt rule, Mr. Forenza. This is Rule 407. This is of the rules of civil procedure, but that same rule applies to criminal actions such as this one. I'll read the relevant sections. Very specifically, let me make some reference. Mr. Forenza has been disrespectful to the court, to opposing counsel, and even to my clerks throughout the proceeding. He's filed spurious documents. He's made nonsensical arguments. He's been argumentative with the court. But I was willing to let all of that go so we could try the matter. On the day of trial, which I believe was November 24th, Mr. Forenza appeared on time, but stayed in the gallery along with who I believe is his wife. I repeatedly, at least 3 times, but perhaps 4 or 5, told him to approach the court, to cross the bar and sit at table so he could address the trial. Mr. Forenza failed to do so in my direct presence. He told me I had no jurisdiction, left the courtroom, and then amazingly was able to leave the building as well. In any event, he has not returned since November 24th, other than a few pleadings that I'm guessing were filed that day or the day before. I've had no interaction with this case since November 24th.
So while we skip ahead here, Judge Michael just spent several minutes walking through the full legal definition of contempt, every subsection, every condition. The short version, disrespecting a court order or walking out on a judge isn't just rude, it's a crime. And the law gives judges the power to punish it immediately, on the spot, with no warning required. Judge Michael then went through Forenza's behavior point by point, the spurious filings, the refusal to approach the table, the walkout, the 30 wasted jurors, every single box for contempt, checked. And that's where this case truly begins.
I make a finding that Mr. Forenza was under an order to perform, that is to come to the table. He refused to perform in accordance with that order. And even though he had the ability to perform, obviously he was mobile, he was able to make it into the courtroom and then, of course, make it out. He was repeatedly warned, and I note that. I gave him multiple opportunities to approach, and he disregarded all of them. I make a specific finding that I find Mr. Forenza's conduct to be offensive to the authority and dignity of the court. I make a specific finding that he engaged in misbehavior that rises to the level of obstruction of justice. The behavior happened in my presence. The conduct was intentional and willful, and these actions seriously affronted and disrupted the administration of justice. In that regard, I will note that I went and met with the 30 or so jurors who had appeared for the trial that Mr. Forenza simply blew off. I had to explain why that happened, and I had to waste all of their time. I also wasted the time of the witnesses. Mr. Forenza, I didn't waste anybody. Mr. Forenza also wasted the time not only of the jurors, but of the witnesses, counsel, the court, and everyone else. The court finds him in direct contempt. I made a similar record on the morning of trial, but Mr. Forenza had bolted from the courtroom, and therefore I find he was not advised at that time, so at least not in any significant way. And I hereby advise him.
Here's what a lot of people miss. Judge Michael didn't walk in looking to punish anyone. He gave Forenza 3 real options right there on the spot. Speak your piece now, go hire a lawyer, or get one appointed for free if you can't afford it. That's not a rigged system. That's a system going out of its way to be fair, and Forenza turned every single one of them down. Said flat out, I don't want to be represented. At that point, the argument stopped being about traffic laws or jurisdiction. It became about pride. And pride alone doesn't hold up in any courtroom, but that wasn't the whole story. If this case already has you hooked, you're in the right place. Like and subscribe to Court with Mia. I cover the most epic, jaw-dropping court cases you won't believe are real.
I am considering a jail term for the contempt unrelated to the underlying charges, Mr. Forenza. I'm going to offer you some opportunities of how you want to proceed. First, if you wish, you can make the statement of mitigation right now. if you wish to. If you do not wish to, if you wish to consult with counsel, I will give you time to hire your own counsel, but you will remain in custody during the interim. I would even be open to the appointment of counsel if you believe you are indigent. In fact, I would appoint counsel if you were indigent. How would you like to proceed? And if you'd like a few moments to think about that, I'm fine with that.
Is that the only option is how I like to proceed, or can I make a statement?
Right. So I'm offering you option one and options 2 and 2A. Option 2A and 2B. Option 1 is you can make your statement of mitigation right now, right? And without counsel, the only person in the room other than court staff and the deputy is Mr. McCall. We are live streaming. You can make that. If you prefer, you can contact an attorney, and I will set this over for a time where you can make the argument through an attorney. Or appoint, that's 2A. And then 2B, if you believe you're indigent, I will appoint counsel.
Could you explain indigent? I'm sorry.
You meet the guidelines, you're in custody. And so I can appoint alternate defense counsel to represent you in the contempt proceeding if you are indigent. The actual language is in a Supreme Court guidance, which says, Colorado, I'll just read it to you. Colorado Rules of Civil Procedure 107 and 407 provide for the appointment of counsel to an indigent person cited for contempt where a jail sentence is contemplated. I am contemplating a jail sentence, Mr. Forenza. If the court appoints private counsel to prosecute a contempt action, which is not applicable here, or to represent an indigent party for contempt charges, that is relevant here, the judicial department will pay for counsel, as there is no statutory authority for the public defender or alternate defense counsel to represent clients for the sole purpose of contempt. But to qualify, you would have to be indigent, which means you would fit below the guidelines for public defender representation. If you wish, I can print those guidelines out for you.
And when Forenza finally speaks, you can actually hear the frustration. And honestly, it's not hard to understand it on a human level. He genuinely felt unheard. He talks about filing affidavits, sending documents, trying to move the case to federal court. None of it worked. But here's the thing, sovereign citizen arguments don't have legal standing in any U.S. court, state, or federal. Judges aren't ignoring those filings out of bias. They're rejecting them because the law doesn't recognize them. The frustration is real, but the foundation under it isn't. And that gap right there is exactly what cost him everything.
Don't want to be represented.
I'm sorry, I couldn't hear.
I don't want to be represented.
Okay, and you understand that, and I will allow you to make the statement of mitigation right now, but you understand you do have a right to counsel.
The only way to look at it is I never got a fair trial walking into this. He failed to prove jurisdiction, sworn affidavit. The courts failed, personal, subject, territorial. I moved it to federal. I even had documents, which I sent. It was ignored. Everything gets ignored. I'm just, I guess I'll just let you beat me up, throw me in jail, get it over with, because you can't keep me the rest of my life. And then, I'll deal with the consequences and things later. I mean, that's where I'm at.
Okay.
It's not right over a traffic citation where all I did is I came here in good faith to resolve the matter. And it was just, I could get nothing. There's no nature and cause of there. There's no sworn affidavit for me to even move forward on. This court can't move forward on. That's all I asked for. And it was like retaliatory. I just got beat up. That's all this is. It's a traffic citation. It's not a crime. Nobody was injured. If that's, if that's what you call justice and fair, I'm not here to sit here and pick at anybody, go after, and that's not what it's about. When I posted bond for whatever it was, I came here and I didn't run. I came here to settle the matter. And that's all I wanted to do. And I just wanted a fair trial. That's it. But you get in my shoes, and how does it feel when you're just getting beat up and the judge you feel is being biased in the case? I mean, what do we?
What else, Mr. Forenza?
Nothing else.
I'm not. Anything else you want to say?
No, Your Honor. The people are. That's all people are going to say.
The prosecutor just wrapped a lengthy statement about everything the state put into this case. An officer who drove across the state on his own time and his own money. Weekend prep sessions. Years of filings going back to 2023. And even after all of that, they were still offering a plea deal. Still willing to reduce the speeding charge to a lesser infraction just to close the book on it. This wasn't a system hunting Forenza down. It was a system that had bent over backwards and still had its hand out. Keep that in mind for what comes next.
Mr. Forenza, I meant to ask Mr. McCall to make that statement before your statement. I forgot. If you'd like to make a statement to address anything he said, I'm happy to hear more.
Yes, I mean, I just object. I did, like I said, I came in good faith to settle the matter, and I tried. So it's not like I'm gonna skip town to that. That's not what it was. Because if I did that, I would skip town. Now, I didn't do that. I came here to put the court on notice, let them know I was in federal jurisdiction. That's what I did, and I stood my ground for that. I have rights, and it's not about my contract. That's not what it is. And him for saying it's contract, and that makes it a commercial matter. So I'm here to settle the matter. Set off and discharge. And as a secured party creditor, I have a right to do that. An attorney, in fact, representing the estate. So I would like to do that. Let's settle the matter. Let's just wash.
I'll give you an opportunity to resolve the matter, but we're talking about the contempt right now. I view the contempt as your direct and unequivocal disregard of the court's order. What would you like to say in mitigation of that?
Your Honor, it's not. Like I said before, it has nothing to do with that. I wanted to settle the matter, and I feel like I'm running in circles, nowhere to turn, but who do I have to turn to? I'm trying to get this resolved, coming into court and hoping in good faith that you do the right thing. And it just didn't seem like it was going that way. And I've never gotten any response to anything I've ever submitted. And that's what makes it hard. So how do you react to that? I mean, what do you do? Me, my situation, I'm scared. Okay, well, I haven't, torture cuffs and sitting here over a traffic citation. Missed my daughter's birthday yesterday.
Now this moment says everything. After the prosecutor finishes, Forenza gets the floor again, a second chance to speak directly about the contempt. And instead of addressing why he walked out, he goes straight back to contracts, jurisdiction, and wanting to settle the matter. Judge Michael asked him point blank, "What do you have to say about refusing that court order?" And there was no real answer. When someone can't address the actual issue even when given the mic, it stops being about the justice system and starts being about whether they're truly present in the conversation. That's the quiet turning point of this entire case.
Anything else, Mr. Forenza? Okay. Court finds the underlying offense can be resolved. As Mr. McCall points out, these cases are frequently resolved on the first appearance for a fine and be done. I find that Mr. Forenza, I don't know about negotiations. That's not my area. But I find he's not litigated this in good faith. I find that he absolutely and unequivocally disregarded a repeated order of the court to come to the table on the morning of his trial. The remedy Mr. Forenza had would be to have the people try to prove their case beyond a reasonable doubt. He absolutely positively refused the court's order, despite repeated statements. It follows up a long history of disrespect from Mr. Forenza towards the court, and more specifically, the entire judicial system. I find there to be no good faith by Mr. Forenza. I am not addressing the underlying case. I do note that there's a new speedy trial date in that case. That new speedy trial date is July 8th, 2026. I thought about rescheduling the trial today, but I'm not going to do that. I'll do that at Mr. Forenza's next appearance. As to the contempt itself, and this is only as to the contempt, I note the difficulty. My plan was coming in to give 30 days jail, given Mr. Forenza's statement of indicating of the difficulty this has caused him. I'll reduce that a little bit, but not much. This case, I hereby sentence Mr. For direct contempt. I sentence Mr. Forenza to 25 days in jail. Furthermore, I set this matter for hearing on my next in custody docket. I'll put him, though it's going to be a busy day, it doesn't make a lot of difference. Today's the 8th. Yeah, I want to set him in the next round. I'll set him on the Friday, January 23rd, 1 o'clock in the afternoon.
Your Honor,
we'll set trial at that time.
Obligations and things I have to take care of. Can I post bail? I will be here.
So noted. I've sentenced you on the contempt, Mr. Forenza. The next issue will be when I see you next time on the 23rd. All right, is whether I should release you in custody on bond after the contempt sentence is over. There is a presumption that that you get a personal recognizance bond on a case like this for the underlying case, but that is overcome. And let me read you the language, because this is what you will have to address. I would recommend that you consider counsel. I have recommended that before. You have disregarded me, and that is in so many other things. The specific provision that is of concern to me, again, there's a presumptive personal recognizance bond. the arrested person has no ties to the jurisdiction of the court, reasonably sufficient to assure his or her appearance, and there's a substantial likelihood that he or she will fail to appear for trial if released upon his own personal recognizance. I will address the bond issue if you wish. The people are on notice that I'm open to bond, but Mr. Forenza will not be released until the 25
I
days.
feel like this is just retaliation more. And this is what I was afraid of at trial, Your Honor.
It's contempt, Mr.
What I was afraid of. But I wasn't in contempt. I showed in good faith. I didn't disrespect. I spoke the bare minimum just about jurisdiction. So everything you're saying is that's, your assumption. That didn't happen.
Have a good day, Mr. Forenza.
I have obligations.
Okay, you'll be able to address them upon release. Thank you.
How am I going to do that here? I have obligations on the outside that I have to do.
You'll be able to address those after your sentence.
Final Judge Michael originally planned 30 days, then dropped it at 25 after hearing Forenza mention his daughter's birthday and his outside obligations. That's not a cold judge. That's a man doing his job with room for humanity. I'm going with Judge Michael on this one. Forenza had every door open and he closed every single one himself. Was 25 days the right call for what started as a speeding ticket? Drop your take in the comments. That's a wrap on another epic case, and honestly, I have so many more where that came from. Drop a comment and tell me what you thought, and make sure you're subscribed to Court with Mia so you never miss the next one. See you there.